Hello, I'm Bernell Alexander. I'm a second year law student at Atlanta's John Marshall Law School with an interest in intellectual property law. I have a biology undergraduate degree and I plan on sitting for the patent bar exam in the coming year. I'm serving as the 2021 IP Fall Institute Law Student Reporter. Hey Franklin, in an effort to create a more efficient and personalized healthcare system, which seamlessly integrates and is capable of individualized therapeutics, treatments to patients, and other forms of healthcare, is a breach of patient privacy and certain information security laws almost inevitable to ultimately evolve in the field of digital health? What are some of the implications that you see stemming from this?
To be blunt, no. There should never be a breach of a patient's right to privacy. If advancements in the delivery and quality of patient care are being rolled out, then the first priority should be the ethical and legal development of those advancements. While the laws, rules, and regulations within the healthcare industry are numerous and complex, they're luckily built and designed with a framework in mind that allow for the ethical and legal research and development activities that can build upon properly obtained patient consent, but also patients that are educated and aware of the decisions they make when choosing whether or not to allow their health records or other personal information to be used in connection with such advancements. So ideally, no, never should be a breach of their privacy, but it should definitely be a development that's done in conjunction with their knowledge and consent.
Hi, my name is John Pierce. I'm a 2L at Texas A&M University School of Law, and I'm a law student reporter for the IP Fall Institute. I'm currently a registered patent agent and really excited to be a part of the ABA. Hey, Franklin, going forward, what are the protective measures emerging from the fields of computer science and cybersecurity? How are they being implemented in our healthcare system? When these new protective measures are implemented, are third-party cybersecurity software companies able to access patient information? How is that being regulated?
So there are definitely emerging protective measures when it comes to information security, InfoSec, or cybersecurity. The biggest ones being all of the state regulations, all the various state laws that are coming into play now, starting with California, Colorado, Nevada. Seems like every week or month now we're getting updates from states saying they're going to have their own privacy laws. So I think that's one of the most emerging and pressing issues in the field of information protection, cybersecurity, and just generally privacy as a whole. And taking a step back, I think a lot of it stemmed from GDPR, so out of Europe, out of the European Union, kind of the very forward-thinking privacy regulations that they enacted that then California piled onto here in the US. And so it's been snowballing from there and leading towards hopefully we might see federal regulation here in the States to understand what's going to be on the horizon. So there have been a couple initiatives in that area. So we'll keep our ear to the ground for that one. With healthcare specifically, there are, of course, two major players, so HIPAA and high tech. Those are the two protective measures, if you want to call them that. Those are the legal frameworks to really understand and to know about when it comes to healthcare data and patient privacy and patient rights. But even so, more so, the power being put back into the hands of the patient when it comes to newer initiatives such as interoperability or information blocking to ensure that a patient's records can be taken from one care provider or location and carried with them somewhere else. And that's kind of really where we're seeing some advancements here, is the power that's being put back into the patient's realm when it comes to how they have access to their health information, where it can be sent and what can be done with it. That's definitely an interesting area that's emerging currently. So when third-party vendors or software providers of any kind, whether they're cybersecurity related, privacy related, or something else entirely different than that, come into the picture, they definitely are impacted if patient information's involved. There's a whole different level of considerations that have to be put in place. Probably the one most important component there is to do an analysis of whether a BAA is needed. One of the most common frameworks that you'll see from a protective measure is the BAA, or the Business Associate Agreement, and that's not necessarily specific to third-party cybersecurity software companies, or it's just more applicable to any vendor or any service provider that's being involved in the handling of patient information, so protected health information, electronic PHI. So the basic questions that you answer and kind of identify in that is, who is the covered entity, who is the business associate, what's being done with the data, kind of your basic questions. And from there, there's actually a framework already developed for how business associate agreements should be structured. And of course, you can get into negotiating those to be a little more specific or favorable to one party or another, or mutually agreeable. So yeah, those are more of the standards that are already in place when it comes to working with third parties that might have access to protected health information.